It's Termination Tuesday, the day where we talk about your rights to get your copyrights back. Today, the 35 years under Section 203. What even is that 35 years? Well, it's going to depend on what's in your contract. If your work had already been released to the public, then it is probably 35 years from the execution of the grant, which we typically understand to be when the contract was signed, but that is not always the case. Now, what if it had not yet been released to the public? Well, then it is probably another part kicks in, and that's 35 years from the publication of the work or 40 years from the execution of the grant, whichever comes first. In other words, the Copyright Act says, does your contract cover publication of the work? Now, publication is a very unique definition under the Copyright Act. It doesn't match any other definition or understanding of what publication means to you. It really drives copyright lawyers nuts, but that's what we have. So we typically understand publication in that respect to mean the release date. So in other words, if your work had not yet been released to the public, then under the contract, your termination rights probably kick in 35 years from the date it was released to the public, but rely on that on your own peril. It gets really thorny.